It seems to me that the issue is, do we have a prophylactic rule passed by Congress that says you can't do a divisional merger and then a bankruptcy? Or do we rely on the bankruptcy judge to decide when a divisional merger is in good faith and bad faith? Bad faith meaning to avoid your creditors.
What's up, everyone? Welcome to Capital Insights. Today I'm diving into something absolutely fascinating that's happening in corporate America. Ever wondered how big companies sometimes dodge their responsibilities through bankruptcy? Stick around because I'm breaking down a recent Senate Judiciary Committee hearing that exposes exactly how this works.
When a divisional merger is done, and then there's a bankruptcy, and you have two companies, I'll use the terms rich co and poor co, as opposed to good and bad. Does the bankruptcy, I assume that counsel for the creditors is raising fresh hell and saying this divisional merger was in bad faith and it was only done to avoid liabilities. Assume that's one of the allegations. Does the bankruptcy judge then hold a hearing and look to Porco and its present and prior management and say, tell me why you did this divisional merger? And if they say to avoid our liabilities, does the bankruptcy judge then have authority to say, no, get out of my courtroom?
The answer to that would be yes. I'll unpack it just a little bit if I can. So you do the divisional merger. There's nothing strange about a divisional merger in concept. I mean, you can have perfectly appropriate divisional mergers and nobody thinks about it until we end up in bankruptcy. But if you do a divisional merger and then you put bad co or poor co into bankruptcy, and the creditors, the victims, challenge the bankruptcy, say it was filed in bad faith, then the bankruptcy judge assesses the divisional merger, the Texas two-step, and determines whether it belongs in bankruptcy or not. And the standards that courts use vary a little bit from court to court, but the standard that will apply in Johnson & Johnson, for instance, which is the Third Circuit standard, the Court of Appeals for the Third Circuit, what the court will ask is, was there a valid bankruptcy purpose? That was the first question. And then the second question is, was this bankruptcy filed simply to gain a tactical advantage in litigation? And if it's not a valid bankruptcy purpose or it was solely for a tactical advantage, the court will kick the case out. And there is a hearing in Johnson & Johnson in its divisional merger case next week to address that question.
Let me ask Mr. Zumbro. It seems to me that the issue is, do we have a prophylactic rule passed by Congress that says you can't do a divisional merger and then a bankruptcy? Or do we rely on the bankruptcy judge to decide when a divisional merger is in good faith and bad faith? Bad faith meaning to avoid your creditors.
Senator, I think that's right. I think the bankruptcy courts are in much better position to evaluate those issues than Congress. I don't think a law that flatly prohibits a bankruptcy filing after a divisional merger is appropriate or necessary. I did a divisional merger recently for a media company that needed to sell a content library. So if that company that bought the content library needs to seek bankruptcy protection in 10 years, why should it be precluded from doing so? I think the courts can make these determinations on a case-by-case basis.
I understand. Could I ask, Mr. Chairman, for 30 more seconds, could you weigh in on that, Mr. McClain?
Absolutely. First of all, what Mr. Scale said, what Professor Scale said, is not accurate in the Fourth Circuit. In the Fourth Circuit, where these bankruptcies are all originally filed, bad faith is not enough to dismiss the bankruptcy. A judge could find it's in complete bad faith. It's a scheme. It's a fraud. But yet, if the defendant, if the debtor can argue there's a reasonable likelihood of a successful reorganization, a standard which is almost impossible to meet, then the bankruptcy has to stay. So dismissal is not an adequate remedy, even for bad faith under the law of the Fourth Circuit, where they, of course, file. Secondly, with respect to this prophylactic rule, think about the implications of what I've just said. The court's hands are bound. They're bound by this governing, controlling precedent, and it doesn't matter if it's bad faith. That's not enough. Judges are, of course, faced with the cases in front of them, and they do their best faced with the cases in front of them. But when there was such a widely used scheme where the wealthiest corporations go into bankruptcy to disadvantage some of their disfavored creditors, that is a universal problem that I would submit calls for a universal answer.
Can you believe that? So there you have it, folks. A perfect example of how corporate America sometimes operates in the gray areas of the law. If this kind of content interests you, and you want to stay informed about these crucial issues, don't forget to smash that subscribe button on Capital Insights and join our community. What do you think about these corporate strategies? Drop your thoughts in the comments below. And if you found this video helpful, give it a thumbs up and share it with someone who needs to understand what's happening in the corporate world. See you in the next video.